We have major breaking news involving the Second Amendment breaking out all over the country today on a Friday. Specifically, we have two decisions by the U.S. Supreme Court to consider the Snope versus Brown case, as well as the Ocean State Tactical. We'll bring you an update there. And a major situation is developing down there in the United States Court of Appeals for the Fifth Circuit out of Mississippi, Louisiana, and Texas, dealing with suppressors and silencers. Let's talk about it now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America, thanks to the 2025 Gundies Awards. Thank you all for your support. I really do appreciate it and hope to continue to try to do great work for the Second Amendment here at the Four Boxes Diner. Okay, folks, so we have major breaking news. First of all, out of the United States Supreme Court, the Supreme Court has issued two orders today. One in the Snope versus Brown case dealing with Maryland's quote-unquote assault weapon ban, AR-15 semi-automatic rifle ban. And the second order by the U.S. Supreme Court in the Ocean State Tactical versus Rhode Island case dealing with magazine capacity limits. Both of these cases have now been scheduled, thanks to the U.S. Supreme Court, for another conference on February 21st. That's next week, February 21st. The Supreme Court, again, the justices will sit in a room amongst themselves and by themselves and will consider whether or not to hear one or both of these cases. Now, we've talked about this before. Given the fact we're now in late February, this means neither of these cases will be heard this term of 2024 through 2025. That means we're now cheering for the Supreme Court to grant cert in one or both of these cases for the Supreme Court's term starting in October 2025 and continuing on into June of 2026. So while on one hand, you can be pessimistic about the fact they have not taken these cases yet, and you might be thinking what's going to happen here is they're going to deny cert in one or both of these cases, and someone is going to write a dissent from the denial of cert saying we should have taken this case. It's crazy we're not taking these cases, but we don't know that yet. It may simply have been the case the Supreme Court, for various reasons, has decided to push these cases off to be heard next term. That is not unprecedented. We saw what they did in the Dobbs case dealing with abortion, which is the case that overturned Roe v. Wade. That case had been relisted, meaning scheduled for multiple conferences, somewhere in the order of magnitude of 15, 16, 17 times or something like that. It was a lot. Then they granted cert, and then they moved forward and they overturned Roe v. Wade. So it's not unprecedented. This is possibly what's happening, that the Supreme Court is planning on pushing this case in the next term. That would not be a shock to me on one level. Why? Because there's another very important gun-related case, and I know we've talked about anything that touches on guns from the perspective of the justices themselves, it's viewed as a Second Amendment case, even if it doesn't specifically deal with the Second Amendment. And we know in March there is an oral argument involving the government of Mexico's lawsuit against the American gun industry, which is almost certainly a lawsuit that will be flushed down the toilet by the U.S. Supreme Court on a whole host of grounds, including but not limited to, they're not going to allow the government of Mexico to engage in foreign policy efforts against the United States and our industries using American courts. Nevertheless, that is viewed, I am sure, in the minds of the justices as a Second Amendment case, even though technically speaking, that is a causation case as well as a potential Protection and Lawful Commerce and Arms Act case. Now, with that said, let us hope and pray that the Supreme Court decides to grant cert in one of these cases and schedule it for argument next term in October. We will see what happens. We're all cheering for Snope versus Brown, and of course, Ocean State Tactical versus Rhode Island. If anything is going to be granted cert, it will likely be Snope. I think that's the cleaner, easier case than magazines. But again, we could see a grant in both cases. So again, only time will tell. Now let us talk about the other breaking news in America today, touching fingers with the Second Amendment. That is the United States Court of Appeals for the Fifth Circuit. You may recall a video I did talking about the case of United States versus Peterson that found in a 3-judge panel that, guess what? Suppressors are not protected arms. Specifically, suppressors are not arms according to this 3-judge panel decision. I pointed out to you in the video the many reasons why this was simply wrong. Wrong. Well, I'm happy to report that it was just announced by the U.S. Court of Appeals for the Fifth Circuit that the mandate in that case of U.S. versus Peterson is being withheld. And what does that mean, Mark? Here's what it means. When a U.S. Court of Appeals issues an opinion, at some point thereafter, it then issues what's known as the mandate. The mandate is exactly what it sounds like. It's something that's mandatory. Of course, that's where mandate comes from, mandatory mandate. A mandate in the Court of Appeals is a directive by the U.S. Court of Appeals to send the case back to the lower court, district court in this case, with the mandate to follow the instructions of the opinion of the Fifth Circuit and to continue the case moving forward down there in the district court. The lower court and the Supreme Court and no one can act on the case until the mandate has issued. The opinion doesn't really count until the mandate has issued. It was just announced by the Fifth Circuit this afternoon that the mandate in the U.S. versus Peterson case will not issue yet. The mandate has been withheld. What does this mean now? What it means is that the Fifth Circuit Court of Appeals, someone on the Fifth Circuit Court of Appeals, some judge, has looked at that opinion by the three-judge panel and said, no good, bad, not right. Some judge has said exactly that and is by authority under the rules for the court can say, don't issue the mandate. We need to look at this three-judge opinion. We may need to en banc it, which means for the entire court to hear, we may need to issue an en banc ruling here and hear this case en banc because we think that three-judge panel messed up big time. By the way, this YouTube channel, this Rumble channel, Four Boxes Diner specifically said that decision by the three-judge panel that says suppressors are not arms under the NFA or otherwise. It's just not arms. That is wrong. There's no doubt in my view that suppressors are arms as defined by the Second Amendment's right of the people to keep and bear arms. Suppressors are arms for many reasons, which we've talked about, not least of which is that they're an instrument that facilitates armed self-defense. Moreover, if you ban suppressors, what have you done is you've banned an entire category of a particular type of firearm. That is a firearm that is capable of firing suppressed rounds. And there's other reasons why suppressors are, of course, arms in addition to those two obvious points, such as the National Firearms Act literally defines suppressors and silencers as firearms under the NFA. Okay, with that said, this is important news because the fact that a judge in the Fifth Circuit has actively stepped up and ordered the mandate in U.S. versus Peterson to not issue means they're likely, in my view, going to seriously consider reconsidering that case en banc. And if they do that, I think the Fifth Circuit will come out the right way and conclude with the right answer, in my view, which is that suppressors and silencers are arms under the text of the Second Amendment, which of course reads, the right of the people to keep and bear arms, including suppressors, shall not be infringed. So there you have it, folks. Some major news today out of the U.S. Supreme Court in Snope and Ocean State Tactical, and major news out of the U.S. Court of Appeals for the Fifth Circuit, touching fingers with suppressors and the National Firearms Act. I wanted to bring this all to you today because we want to keep you abreast to make you the smartest person in the room. Okay, folks, so hope you enjoyed today's show. Make sure you subscribe both to Rumble and YouTube. Don't forget to like this video and make sure you follow me on X at 4 Boxes Diner. I look forward to talking to you very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.